I want you to imagine this. You went into a five-brother shop to buy phone, probably an iPhone or Samsung. And then the buyer there told you that this phone, not only that it is a brand new phone, but this phone battery can last even for 1 week without reducing to 20%. Trust an Igbo man now. Trust a Yoruba man now. Trust an Hausa man now. Yes, you think I will only stop with Igbo man. Na lie. All of us love money, including you, Yoruba woman watching this video. We all love money. So, this phone you have bought come with a warranty or a guarantee, as we popularly call it, that the battery and everything, both the software and the hardware aspect of the phone is going to last. And now you came back with that phone, only to use it, in fact, to download some certain app you will be making use of with the phone. And then the battery switch off in 30 minutes time. Now I want you to pause. What do you think will happen in this case? What are your rights in this case? Can you return the phone, cancel the entire deal, or demand for repair or compensation? This is basically what the terms of contract is all about. And in this video, I'm going to take my wholesome time to explain to you the terms of a contract, the difference between terms of a contract and that of representation. By the way, my name is Kingsley Ifeanyichukwu, better known as King's Advocate. I'm currently a 400 level law student, and what I do on this channel is to help all students, especially law students, in the challenges of becoming tomorrow lawyer. If what we do here resonates with you, you are interested in receiving video that clarifies some certain hard topics in law, you can consider subscribing and turning on the notification button so that every single Friday, Saturday, and Wednesdays when we post a video, you'll be able to receive it. Without further ado, I'll be giving space in this our whiteboard animation. The purpose is to enhance our understanding, because I learned that I often obstruct many people while I'm teaching. So I want to give space where we can all solve this problem together. And by the way, I would like you to help me with advice. Do you want me not to be showing on the screen while we solve any particular topic we are treating on? Or do you want me to be speaking to you until we end it? Which option is better for you? I would like to hear from you, because I'm serving you. Yes, anyone you choose will go well with me. Kindly tell me, my name is this, I'm watching from Enugu State University, I'm watching from Uni Lagos, and then I want you to use this aspect, or I want you to make video on this topic. I will really appreciate it, because it shows that I'm talking to a human being, and I don't want to be making something that suits me, but what suits you, what will solve your problem. So don't hesitate to tell me anything you wish here. We are all future lawyers, we are all learning, so don't hesitate to always do that. At this point, while we progress to solve this problem together, it is also important to note that this very topic we are dealing with is a first semester topic that is going to come, or you are going to encounter it when you are done with definitions of contract, element of contract, and all whatnot. That is when you are going to expect this term we are about to treat now. Now, every contract, whether for buying a car, a phone, or even renting a house, contains some certain promises. And these promises, as regard to this topic, is what we call terms. So I want you to know this point. Every contract contains what we call promises. And these promises is regarded under the law of contract as what? Terms. But then, not all promises carry the same weight. Like I told those who started with us in our first video on Introduction to Contract Law. What makes a contract different from every other thing depends on the element that was fulfilled. Today, we are done with all those things. We are facing terms of a contract. So to understand it, you should know then that the reason for this topic is the fact that not all contracts or all promises carry the same weight. Some are so important that breaking one of them, breaking a single promise, can destroy the entire agreement altogether. That is what you have to know. So others are minor and only attract compensation. To make this lecture video very easy and easily digestible for you, I would like to even tell you what are the contractual terms, because I've been mentioning it since the opening of this video. But what are the contractual terms? One may ask King's Advocate. The terms of a contract or contractual terms basically refer to the promises or obligation that each party agreed to carry out. They defined the who, what, how, and when performance is to be made. Let me just take it that again. Terms of a contract are simply the promises or obligation that each party to a contract agreed to do what? To carry out. They then define the who, what, how, and when of a performance. In other words, these are the things that determines who will perform a contract, who has liability, and how will it be performed. I will just give you a quick instance here. Let us assume you buy a car. The seller term is to deliver a functioning vehicle. Your own term here is to do what? To pay the agreed price. Now, term can either be express terms or implied terms. It's just like if you have started this journey with us where we discussed the types of a contract. I told you that we have express contract and we have implied contract. Now, we are coming with this analogy again as regards to terms of a contract. I told you, based on the example I gave you at the opening of this video, I started with a very, very bright example to tell you that not everything is obviously pronounced in a contract, but they still have effect. Now, when you are dealing with express term, just like the name suggests, express, simply means those things that are clearly stated. They are written down. They are spoken. Like, they are very, very clear. Like, an example to this is delivering within 7 days. You and the what? The buyer agreed, or you and the seller agreed that he or she is going to deliver to you within what? 7 days. This is a typical example. We talk about implied terms. Implied terms, on the other hand, means that they are not stated. They are not written down anywhere. But because they are not written down anywhere, does not mean they doesn't exist. They can exist based on the fact that it could either be recognized by law. That is, one particular law has said so. Whether you, Taiwo, is so ignorant of the law doesn't care, because Section 22 of the Criminal Code made us to understand that ignorance juris non excusat. Ignorance of the law is not what? Excuse. So for the fact that you, Taiwo, is not aware that this thing should be in this contract does not make it, exclude that clause. I'm still going to treat on next Saturday on our lecture video. I'm going to take you on exclusion clause. So subscribe if you have not done so. Now, your ignorance does not mean that it will not be there. We have sale of goods. Our sale of goods have made a lot of, provisions, which ordinary, in fact, even lawyers struggle to understand what sale of goods mean. I could remember in my third year how I was battling to understand sale of goods act. You can imagine non-lawyers. So if you are making a contract with a company, with an individual, it doesn't matter whether you are aware of this. Once the matter happens, once things go bad, and you come before this honorable court, the honorable court, my lord, is going to read a commercial transaction, sale of good act into your contract, whether you recognize it or not. That is what we mean when we say the implied. The law have implied it. Then there are also at times the law have not implied anything. The law is silent. But the court is going to use their own initiative to imply something. That is what we call now judicial precedents and case laws and also many more. The courts have already had the way that thing work. They will imply meaning into it. Then there is also another thing known as custom. I believe you are following me. Please, if you are not understanding, always put it in the comment section and I will attend to you. The reason why I'm trying to be so explanatory is for you to actually understand every single thing that is ongoing. Now, when we talk about customs are those ones that have become common. For instance, if you are in a aggregate bus stop, the implication there is that you are waiting for a bus to take you, right? That is the implication. So any bus that comes in there and stop and you enter, you didn't tell the driver, I want to go here, I want to go here. Yes, you didn't sign any contract, but the driver stopped. Possibly the driver may not even talk to you. You may not even talk to the driver. You will enter from aggregate bus stop or from Okwara Square. You enter and then it will drop you in Agric Bank. It is expected that when you stop at Agric Bank, you are going to pay money. So once you have reached Rumowara or wherever you are coming from, it is expected that once you stop there in Rumodara, you are going to pay money. Now, paying that money is what? Implied. That is custom. Custom has told us that whoever that's entering a bus is going to do what? Pay something. I believe with this, I have clarified you what we mean. And it is also important to note that Sales of Goods Act implies some certain terms into a contract. You will encounter this in your third year, don't worry. Merchantable quality is one of them. That is when you are buying something, it is expected that that thing you are buying should be in a safe condition for use and for consumption. The question is, what are the types of contractual terms? Very important. Even if you will not learn anything today from me in this video, make sure you take this one away. Types of contractual terms, because they will determine how you are going to advise party, how you are going to write to your lecturer, how you are going to tend to your problem question. I believe you should know that this is going to come in problem question now. So if you don't know it today. Under types of contractual terms or terms of a contract, we have number one as what? Condition. The question is, what is condition, King's Advocate? A condition is a major term of the contract. It goes to the root or heart of the agreement. If that term is broken, the innocent party can end, that is, terminate the contract or completely claim damages. I will just take that thing again. A condition is a major term of the contract. It goes to the root, to the innermost circle of an agreement. And if that term is broken, the implication is that the party can end, that is, terminate the contract completely and then claim damages. Now, think of it this way. Without these promises, I wouldn't have entered the contract at all. That is what condition is trying to tell you. Without these promises, like, I carry back this contract, but you made me to enter this contract because of this promise. Therefore, that thing becomes the condition. That is, sometimes we do have, I'm still going to explain to you as we progress. Just only thing you will do for me is subscribe. But once I'm here for you, you are going to pass this contract law. Contract law is not hard. I'm here for you. When I'm going to tell you now about condition precedent, also explain to you what condition subsequent means. Condition in this case could be precedent in the sense that this thing is what ought to exist before you could talk of a contract. Subsequent in the sense that this thing ought to happen before we talk of a contract. In our next video, we are going to discuss that. Let's focus. So, example now, you buy a car that the seller promises that it is a brand new. You went and buy a car, and then the seller told you that, see, this car is a brand new. It happens that when you start the car, the engine is completely ruined or dead. In fact, you didn't even drive a kilometer away from the shop, and the engine, collapsed. The question now is, what have happened here? What have happened here is a breach of condition. What was the condition? That this car you are buying must have a good engine. It is one of the condition precedent that, of course, it is only a madman that will go and buy a car that its engine is dead. Will you? We then move to the second types of terms of a contract. The second types is what? Warranty. What is a warranty? A warranty simply means a minor term, not the root of the deal. So you can see warranty this way. Warranty has to do with the fact that if broken, the contract will still do what? Stand. But the injured party can only ask for what? Damages. Let me just give you this example. You buy a new car that arrives without a spare tire. Of course, you know that each car, I don't want you to see it as a Jeep now. Each car that comes anytime always comes with a spare tire. But the problem, I can remember when we were a child in primary school, we thought that any car that has come with a spare tire must be Jeep. What we didn't know that time, it was just how that Mercedes structured their vehicle, that it come with car at the back. And that was how we were rating Jeep back then, that it must have tire at the back. But each car, either beneath or above, must come with what? Spare tire. It's just the rule. But it depends on where they place tire. Now, if you bought a car, and the car didn't come with tire, you have ascertained the car, you have checked everything, and then you have returned back home. Only to discover that where the tire is supposed to be, the tire is not there. And you then went to Stanley and say, Stanley, how can you sell me this car when I'm supposed to have the spare tire? In fact, are you okay? And then Stanley will be like, I'm sorry, that was a mistake. Or in fact, Stanley may not even own up to it. If I tell you that, in fact, I don't know what you're saying. And then you'll be like, are you crazy? Are you okay? In fact, I'm not doing it again. I want my money back and take your car. Stanley will be like, whoa, Mr. Man, the beautiful thing about this contract is that even the money you paid is no longer with me. As I'm talking now, I've made an order from China for some parts that are going to arrive in Alaba International Port soon. So please pay me this thing you are talking of. Like, you will be bubbling with anger. Before you know it, you don't institute an action. Possibly in Lagos State High Court, depending on the situation of the place where it happened. I'm not teaching you jurisdiction. So the court will be like, the issue before my Lord now is whether the breach of, let us assume, whether the breach of condition or whether the breach of your entitlement of having a spare tire that comes with every car have amounted to a breach of contract or have given rise to your right of repudiation, that is right of termination. That will be the question before my Lord. My Lord, in his ultimate wisdom and chamber, will look at your case critically and say, well, you can't reject the whole car. My Lord is delivering his judgment. You can't reject the whole car. He still drives, okay. Look at now, are you okay? Taiwo, your car is still moving. In fact, when you on your car, all of us can hear the sound. what again is your problem? Is it because simply we didn't, get the additional tire that is your problem? Okay, since that is your problem, do you know what? We are giving you damages. It's as simple as that. If that is your problem, let's award you damages to compensate you for not having the tire in the first place. In fact, Stanley, deliver some tire to him. This is what a common reasonable person should be looking for. Because you not say that because you didn't get the additional spare tire, you will reject the entire contract. What are we saying? We are saying that this is a breach of warranty. And a breach of warranty in the law, in contract law, does not give rise to what? Repudiation. But it gives rise to what? Damages. If you understood me, can you give me a like? Can you comment? Kingsley, King's Advocate, thank you, sir. Just say it. But if you don't understand, also ask me questions. And I'm going to answer you. Go to my comment and see that I always reply. I want you to pass because I love you so much. Now, we have achieved what? Warranty. And I believe that every person who have listened to me carefully and diligently have understood what I mean by what? Warranty. So the third one is innominate.
Law confusing. Let's make it simple. At lawmadesimplelegal.com, we break down the hardest legal concepts into easy-to-understand lessons. Whether you're a student, lawyer, or just curious, you'll find clear explanations and real case analyses across fields like criminal law, contract, tort, and constitutional law. This is where law becomes easy and practical. This platform was created by Kingsley Omenyi, simplifying the law for Nigerians and beyond. Visit lawmadesimplelegal.com or simply scan us on Google to discover how easy law can be.
Intermediate step. It is either you call it innominate or what? Intermediate. Before I continue, this is where most of the students, contract law students, find it very difficult. But I would like to tell you that when we talk about innominate, what we simply mean is something that is not named or not classified. That is what it means. That is the English definition of what? Innominate. Not named, not defined. What is it trying to say? These types of contractual terms sit in the middle between condition and warranty. So you cannot say that it is condition and you cannot say it is warranty. But rather it depends on how the court interprets it, looking objectively into the facts of case before him. So it is called innominate because it is not given a flexible or feasible name. Now, this same term can be sometimes be treated like condition. And sometimes it also can be treated as what? Warranty. Pay attention. Here is the key question this particular terms of a contract seeks to answer and ask. Does the breach deprive the innocent party of the main benefit of the contract? If yes, it is treated like what? Condition. If no, it is treated like what? Warranty. Now, I have given you example. Let us assume now you sign a 1-year contract with one particular network. Let me use Glo. Trust Glo now. They always have steady network. Bok. You can enjoy time. They agreed or you signed a contract with them to provide you network for about 1 year uninterrupted in your building. Now, these people have been giving you this network, but one day they fail for 2 days. Only God who knows whether Glo will fail you for 2 days. They fail for 2 days. Not only that they fail for that 2 days, every dividend you are entitled to have that day was collapsed. And you are a busy guy, you use this to run your business, possibly a TV station or radio station. And now, you say, do you know what I'm not doing again with Glo? I want to terminate this contract. And the contract is still having additional 11 months or 10 months to go. You are not even started, but you want to cut the contract short. The court will be like, well, the issue now is whether or not a breach of not providing you network for 2 complete good days have given you the right to repudiate the contract and to seek for damages. The question has been asked before the court, but the court will be like, in this case, is 2 days enough? Just like we saw in the other case of Stanley and their Jeep issue. Is 2 days enough for you to just say that the contract you have with somebody for 1 year, failure to give you that in 2 days is enough for you to terminate the contract? The answer before any reasonable man will be no. Because come to think of it, minus 2 days out of the, I think they told us that 365 days that are in a year, 366 in leap year, minus 2 days is not even a little bit compared to what we stand to enjoy. This is a breach of what? Can somebody tell me what this breach have given rise to? Because it is that breach it has been given rise to will determine how we are going to terminate. This is obviously have given right to what? Breach of warranty. And breach of warranty, will it give you right to terminate a contract? No. What will it give you right to do? Put it in the comment section. I want to hear from you. But let us assume now that if the network fails to provide for complete 6 months, 6 months divided by 12, 6 divided by 12 is what? The law. I know you don't know maths now. Me too, I don't even know. But what we are trying to say now is, if you minus 6 months from 12, you already have 6 months. So a breach in this case now, if the network Glo trusts them, they can do that. They fail to provide you network for 6 months. What the contract you have with them is what? 1 year. In this case, if you go to court, the court will hear your case and will terminate the contract and also award you damage, because the breach here is very, very substantial and material. It's very, very too big. Come to think of it, half of a year is gone and your contract is still, your money and everything went into it. You have the right to terminate because the breach has given right to what? Condition. So do you see when we say innominate, it simply means that it can be warranty, it can be condition, depending on what? The fact of the case. Hope you are with me. Now, let us move ahead to another terms, which is what? Fundamental terms. Can somebody pronounce with me? Fundamental term. What this thing means is that a fundamental term is a promise that is so essential that a breach in it or a breach of it changes the entire contract and its nature totally, as was agreed. So it is very close to condition, but it is often used in cases involving what? Exclusion clauses or serious misconduct. The law, I also found it difficult when I was in year 1 or year 2. One of the issues there is that you always find it difficult to distinguish between fundamental terms and condition. But what helped me is the way I saw it. I saw condition as what ought to exist before a contract, and then decide on also what ought to exist after a contract. But I saw fundamental term as something that could be a coincidence, that could go a long way to alter a contract that, the court will see that hardship has been done to the beneficiary, that they will have no other than to know that that contract should come and end. That is how I see this thing, and I want you to see it the same way, so you will not go mad in this journey. Now, example is this. You rent a furnished apartment. When we say furnished apartment, there is a presumption that that apartment should have everything you need. Like everything would have bought, and just like buying something that is very complete. You bought a hotel. By buying a hotel, the implication is that everything that is needed for human habitation has already been provided because I bought everything. Now, that is what we mean here. You bought a furnished apartment, but when you move in, you discover that it is completely empty. Completely empty means that the furnished apartment you bought, furnished there, which have been taken care of by your money, none of those conditions were fulfilled. So this is not a small mistake. The whole purpose of the agreement has been destroyed because you actually would have, rented a building, but you bought because you don't want property, you don't want to buy astronomers property. So what then is the use? Because this is so fundamental. This one pass conditional, this one pass warranty. Everything, in fact, totally is coming to an end. What I want you to take away from this is this. Condition equals to vital promise, and breach will give rise to what? Termination of a contract. Warranty equals to what? A minor promises. And breach will give rise to what? Damages only. Damages only. Innominate time depends on what? The seriousness. That is, the judge will decide. It depends on the discretion of the judge to check the fact, to know whether this one is given rise to what? Warranty or a guarantee. So innominate is still like a lukewarm water that has no base. We talk about fundamental. Fundamental breach is so bad that the whole deal has to collapse. There is no option than to collapse it. And in my next video next week, we shall continue with what? Expansion of this principle. We shall dissect all the cases you need to be able to pass this topic. So I believe this helped you. Remember to like the video. Now, before we continue, I want you to know that we have made a lot of videos on contract law that covers this topic. So click the videos above in your screen now. These videos are going to lead you to find all the videos, both the one we have done starting from everywhere on contract law. Click it and I'm going to see you there. Also remember to share with your classmates in your growth group because we are in this journey together to help each other.